justify it yet. It's gone as far as dealing with those networks that are accessible to the public, such as small Wi-Fi cafes and so on. But the question has been asked, why are these powers, some of them extended that far before, but there is a big shift to extending these powers to private networks now. Equipment interference was always going to be one. It was probably, apart from the Section 94, the most hidden of the previously exercised powers, so now being debated really for the first time. And of course the extension of data retention, including so-called internet connection records, but also beyond that to all the other types of communications data that could potentially be the subject of retention notice under the new bill. And I think not something unique to this bill, a focus on what is guaranteed on the face of the bill versus what has been delegated to codes of practice, which can be changed relatively easily over time. Probably one of the more prominent examples of that is that the government gave a very public sort of flagship commitment at the time that they announced the draft bill, that they had dropped the idea that had been in the draft communications data bill of requiring ISPs to retain third-party data. In other words, data that is purely transiting over their networks and wasn't used by them in any way or processed by them in any way. It transpires when you read the bill that actually it does cover retention of third-party data, but it's been put into the code of practice that the power won't be used in that way. And the question has been raised whether it's really good enough for a public policy commitment of that sort not to be reflected in the bill itself. So just a summary of some of the sorts of issues that are, as I say, crystallising during the scrutiny of the bill. Come on to the specific question of how the law should deal with advances in technology. You can't go far in that discussion before somebody starts to talk about future-proofing. And we heard it in RIPA, and we're hearing it again in this legislation, the need to future-proof this legislation so that it stands the time and doesn't go out of date in the face of rapid technological change. And how do you do this? Well, there are two main ways of doing it. One is to enact a very broad general power that can cover pretty much anything, and that was the approach adopted for the Communications Data Bill, and that was shot down in flames by Julian's committee, who noted the wide anxiety raised by the breadth of Clause 1 of that draft bill, and who said, "We do not think that Parliament should grant powers that are required only on the precautionary principle. There should be a current and pressing need for them." And the other obvious example as well is Section 94 of the 84 Act, which was written in sufficiently broad and discretionary powers that I personally doubt if it would survive scrutiny by the Human Rights Court on the grounds of certainty and legality, but no doubt we shall see when one of those cases goes to Strasbourg. We see some remnants of that approach in the current bill. Technical capability notices, these are the notices that can be issued to require communication service providers to put in place specific technical capabilities to support the various warrantry and other types of powers under the bill. At the moment under RIPA, those apply only to interception, to support interception warrants. Under this bill, they're going to be extended to cover pretty much all of the various types of powers, and the bill lists the various obligations that can be required, including the famous one regarding removal of electronic protection applied by or on behalf of the service provider, which is the source of the huge debate about encryption backdoors. But the bill says the obligations that may be specified in regulations include, among other things. So So it's actually an open-ended power with simply an illustrative list of items. And the data retention power. To read the impact assessments and the supporting documents and the speeches, one would think that all this is doing is adding internet connection records to the existing data retention powers in DRIPA and IP address resolution introduced in 2015. In fact, it goes far, far wider than that, and will essentially cover all machine-to-machine communications, the Internet of Things, pretty much goes far further, with no attempt to justify it in the impact assessment or the any of the supporting documents, in fact. The other way of trying to future-proof legislation is by doing things, by applying a technique called technological neutrality. And the way you do this is to avoid using specific concrete terms, technology-specific terms in your legislation, and draft it at a sufficiently abstract level that you think you can cover developments in technology as they go forward. And for many types of legislation, this is a very good thing, a very good way of going about things. But you run into trouble when you do that, start to do that with intrusive powers. It was the approach adopted in RIPA, and David Omand, I think, has gone, but when he was giving evidence, he was the Permanent Secretary at the Home Office at the time when RIPA was going through, and the evidence he gave to on the Home Affairs Committee was that the instructions to parliamentary draftsmen were to make it technology neutral, because everyone could see the technology was moving very fast. Draftsmen did an excellent job of doing that, but as a result, I do not think the ordinary person or member of Parliament will be able to follow the Act without a lawyer. The lawyers had difficulty as well. I won't read you all the comments of all the lawyers who have been unable to make much sense of RIPA or found it impenetrable or complex and difficult over the years. But the almost inevitable result of applying a technology-neutral approach is that you end up with very, very difficult to understand legislation. David Anderson, in his report, ultimately commented that RIPA, obscure since its inception, has been patched up so many times as to make it incomprehensible to all but a tiny band of initiates, and he challenged the Home Office to produce a bill that is both comprehensive and comprehensible. Unfortunately, the IP bill is going in the same direction. The Commons Science and Technology Committee found that the definitions have caused significant confusion on the parts of communication service providers and others including the general public, who are entitled to understand the legislation and the kinds of situations in which the powers will be applied to them. And the Home Secretary said that the reason for their being abstract was they're intended to be technology neutral and flexible, so that should user behaviour and technology change, they will still apply, and as a result, she said, the definitions as they're formulated are necessarily abstract. So you have the Home Office there saying that if you adopt a technology neutral approach to this, you are going to end up with legislation that is very difficult to understand, ending up in exactly the same position that was so heavily criticised with RIPA. So you have a rule of law issue of unintelligible legislation resulting from the technology neutral approach. So there is another issue with this, which is that if you do successfully implement technology neutral legislation, then what you have future-proofed is the powers successfully. What you have not future-proofed is the intrusion and privacy balance that Parliament thought that it was implementing when it considered the legislation. And in a sense that's deliberate, because the powers are intended to follow the technology as it goes in the directions it goes, as it goes deeper into people's lives, as the metadata becomes richer, so the powers will follow, and you have the privacy balance, privacy intrusion balance, changing simply as a result of accidents of technology, not as a result of any policy decision or parliamentary debate. And that is exactly what happened with RIPA. We had mobile when RIPA was enacted, we had internet when RIPA was enacted. We didn't have the combination of the two, we didn't have smartphones, we didn't have the enormous growth of data communications on smartphones that we have now, and the resulting avalanche of new types of data that fell into the lap of law enforcement as a result. So what should you do? I would say that you should throw out that conventional wisdom. You should take a completely different approach, the approach more like what was in, for instance, the 2009 data retention regulations, have a concrete technology-specific list, sunset the powers, take it back to Parliament frequently so that Parliament can review what it's done and what should happen going forwards, and in the meantime, in the period in between, have a philosophy of continued openness so that Parliament can, when it does review it, has the information necessary to do so. Thank you.
Thank you very much.
Thank you.